Hey, good morning, Judge. Officer Glass Report, bring you straight down the calendar. Everybody here report.
How can I get rid of it?
Judge, if you're on your audio and your courtroom's open, one or the other. So maybe mute yourself and go to the courtroom.
My audio's on. So how can we have this?
Yeah, I can't tell.
Is that better? Yeah. Okay, can everybody hear me?
Yes, Judge.
Okay. What about Kaiser Suggs?
Morning, Judge. I'm on that case here, Anastasio Simetis, on behalf of Mr. Kaiser Suggs. And I have just a couple of witnesses for community ties, and we're ready for a bond hearing on that.
All right. Mr. Dutcher, is that you?
Yes, sir.
Okay. Go ahead and call your witness, counsel.
Okay, thanks, Judge. They're just Mr. Suggs' parents here. It's Miss Cherry McKibbins and Mr. So Mr. Suggs here. I guess Miss McKibbins, you can raise your right hand for me, please. All right. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, so help you God. Okay, you can lower your hand. And how do you know Kaiser?
I am Cherie McKibbins, Kaiser Suggs' mother.
Okay, and how long has he lived with you?
22 years.
Okay, so that's his whole life. He's 22 years old?
Yes.
Okay, and are you available to have him stay with you still when he's released on a bond?
Yes.
Okay, and are you also available to support him financially?
Yes.
Okay, and if he were to be given a curfew or be placed on house arrest, would that be okay?
Yes.
Okay, and if he was ordered to wear an ankle monitor and you had to pay for that yourself, would you be able to pay for that?
Yes.
Okay, thank you. And has Kaiser been born and raised in Georgia his entire life?
Yes.
Okay. All right, thanks. Thanks so much, man. Those are all my questions. And then, Mr. Suggs, you could raise your hand too. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes,
So
sir.
help you God. Okay, thank you. And you heard the questions that I asked Kaiser's mother. What's your relationship to Kaiser?
Kaiser's father.
Okay, and are you involved in parenting him and raising him?
Yes.
Okay, and are you also available for financial support if he needed it?
Yes,
Okay, and do you have a job available for him?
I do.
And what is the job?
Transport vehicles,
Okay,
from
and
state to state.
okay, so what exactly would Kaiser do for you if he was working for you?
He helped load the vehicles onto the trailer.
Okay, and how much would you be able to pay him for that?
About $600-700 a week.
Okay, and if the judge were to make employment a condition of his bond, would Kaiser be allowed to be employed with you?
Yes.
Okay, and you heard the questions about Kaiser being born and raised in Georgia.
Yes,
Do you have the same answers as his mother to those questions?
I do.
Okay, those are all my questions, sir.
All right. Do you have any other evidence?
No, Judge, just argument.
All right, Mr. Dutcher.
Yes, Judge. Are you asking me whether I have questions for these witnesses?
Either that or your position.
Judge, well, first of all, our position is that we're opposed to bond. This defendant is actually a co-defendant to 3 other co-defendants that I had a bond hearing for before Judge Williams. I believe that was back on March 23rd, 2021. It was co-defendant Carlos Smith, Robert Smith, and George Smith. We had the bond hearing, and each of those defendants were denied bond on the basis of the fact that they may be a danger to the community, as well as there was a possibility to attempt to influence witnesses in the case. This defendant was subsequently identified in the investigation. It's a case out of Union City. The allegation in the case arose back on January 24th, 2021, and it was the shooting death of Marcus Thomas at 4701 Flat Shoals Road, apartment 39G. So essentially what's alleged to have happened is that the Smiths, that's Carlos, Robert, and George, along with this defendant who was subsequently identified during the investigation, went over to that apartment because the Smith's sister, Kamaya Smith, had reported that the victim who resided at that location had done something improper with her. So apparently Kamaya Smith was spending the night with her friend, Miss Redwine, who is either the niece or a relative of the victim in the case. So what it appears happened is that the Smiths and Mr. Suggs went to the apartment and essentially executed the victim in the case, shot him in the head. He was found with a gunshot wound to the head in the bathroom of the apartment. After that, I guess both Redwine and Smith were taken from the scene, and there was a statement made to the witness, Miss Redwine, essentially that she better not say anything, otherwise she could be subject to harm. Additionally, Mr. Suggs is in a position to know the other witness, Smith, who is an essential witness in the case. One of the reasons of the basis of denial of bond for the other three defendants is that she's out there. They would potentially have access to influence her and I guess give her additional information or put her in a position where she may not be cooperative in the investigation going forward. So that was the principal concern. And obviously that's the concern here, is that Suggs is connected to and is close friends, or the allegation is that he is close enough friends with the three co-defendants that he would also be in a position to do that. In the other bond hearing, just like in this bond hearing, neither of the Smiths had a criminal history, and multiple family members testified on their behalf, similar to what's been testified to here. And I believe even the mother of the Smiths in that case testified and gave some information at that bond hearing that her son had called her and told her that they were at the club when they had received a call from their sister, Kamaya Smith. What's interesting about this case is that I believe the detective, when I spoke to him, said that he was able to identify this defendant as being at the club with the other three prior to the shooting, which is corroborated by the statement of the mother who testified at the bond hearing back in March. So once he was identified, we did run his GCIC. There are no felony convictions, but he does have a number of arrests, including one that was of most interest to me, Judge, on June 10th of 2020 for aggravated assault and participation in criminal street gang activity. I don't know the status of that case. I've attempted to get a hold of people in Clayton County, so I don't know what's happening with it. But from my discussion with the detective, this defendant is a known gang member from Clayton County, which raises additional concerns about the safety of people and property and influencing witnesses, that we have a known gang member acting in concert with three other defendants that unlawfully entered, the allegation is unlawfully entered the apartment of another person and committed an act of violence, specifically shooting him in the head. So for the same reasons, I think it is appropriate to deny bond for this defendant as the other three, is that there's a possibility that he could influence witnesses, and that I think he's a danger to people or property, especially in light of the potential gang aspect of this that just recently arose. So I understand that his parents are here to testify on his behalf. I take that with a grain of salt. His dad will give him a job, but the reality is he's been living with them for the past 22 years. Where were they when he was arrested for gang activity or this charge? I don't really take much comfort or solace that will be appropriate supervision. So we're opposed to bond, Judge.
Counsel, does his parents deny that he's in a gang?
Yes, Judge, of course. I actually was his attorney on that preliminary hearing that the state references, which they're right, is not a conviction. Mr. Suggs has absolutely no conviction whatsoever. Situation in that case was he was going to somewhere and was actually shot at, and there wasn't any investigation done at all into what happened. And the people that shot at him lied to the police. And to be totally transparent with the court, Judge, we had a Zoom preliminary hearing, and the preliminary hearing was so humiliating for the testifying officer that we actually were put in a breakout room with Judge Wanda Dallas, and she told the state she was definitely going to rule in favor of the defense in the bond hearing and that they should just go ahead and consent to a bond. And that's how that played out. He posted the bond. He's been completely compliant on that bond this entire time. And I just don't think that should even be considered, Judge.
Well, so it sounds like he's out on bond for the felony offense of participation in gang activity and aggravated assault when this happened.
All right, I'm gonna deny bond. I'm very concerned if he is in a gang.
Judge,
He's a danger to society.
but Judge, there is no evidence of him being in a gang. He's not in a gang. He's never been.
That charge is still pending, and I'm just not gonna take a risk on it. All right, thank you. I'll deny bond. What's the next case? Johnson, Quintarius Johnson.
Judge, that's my case. Is that, Mr. Dutcher, is that your case as well?
Yes, it is. And Your Honor, just I don't know if they need to address the court at this point, but the family of the victim in the case we just heard, I believe, is present here, Miss Orr. Just letting the court know before we move on to the next one.
And Your Honor, please make an argument at least about the bond factors, just for the record. I mean, there's a lot.
Certainly.
Thank you, Judge. And so the allegation here is not just of a misconduct with the victim. It's a rape of a teenager who then called her brother, which is one of these three brothers, to come pick her up. And Mr. Suggs rides along because he's with them at the club. And then when they get there, Mr. Suggs does not go in the house. And then something happens in the house. We don't know exactly what, but we hired an investigator. He canvassed the area. No one says that or very few people say that they heard shots, few than you would expect in a very, very close knit type of serial residences. And so my theory is that it's some kind of muffling of the shot, and it very well could have been an execution, Judge, but Kaiser is not accused of being part of that. And we have not had even a preliminary hearing to say what assistance did he actually provide to the
Dutcher. What is his allegation? What is his alleged conduct?
Judge, from review of the case, it is unknown exactly what happened in there, other than that the victim in the case was shot in the head. So we do know that the group traveled over there acting in concert. So the theory right now is party to the crime. So I don't have all of the information from the detectives, but the allegation is that I guess Miss Smith called her brothers who came over there along with this defendant. I think there's video of this defendant coming through the apartment gate or at the apartment gate, wearing the same outfit that he's wearing in the club. That's what I discussed with him when I spoke to him a couple days ago. And as far as how the actual shooting took place, I don't know if we know the identity of which person shot or if there are multiple shooters. But clearly, we're proceeding under the theory of conspiracy and party to the crime, especially in light of the fact that there is at least a statement from one of the witnesses that she was told not to tell or something along the lines that the same thing might happen to her. So,
and that person is out there.
Correct. That person is, out in the community, along both females in the case. The female that was hosting, the sister of the three co-defendants, and the sister of the three co-defendants is out there.
And is it a situation where maybe this defendant could cooperate?
Where this defendant that we're having the bond hearing on now?
Yes.
Well, I mean, I'm always open to discussions, but that discussion has not been forthcoming. And I guess based on the presentation that we've had here so far, it doesn't seem like that's in play, but I'm always.
Both of the female witnesses given statements?
One of them has, the other one, I don't believe her parents have let her speak to the police. So
That is the alleged rape victim?
correct. And I'm, just to clarify, I don't know if it's a rape, but I would concede that there's an allegation of some sort of improper touching or contact.
Now, the victim's family is here?
Yes, I believe they are on the line. I think maybe it's his sister that's here.
Another sister?
Yes, I'm the sister of the victim, and his one of his eldest children are also present, as well as one of the mothers of one of the children. So it's three of us that's online right now.
All right, please tell me what you want to tell me, and I'm very sorry for your loss.
Thank you so much.
And if you could just state your name for the record, ma'am.
Can you turn on the camera?
Yes, I can, but I would like to ask, I originally spoke with the victim's advocate and requested that that I remain anonymous because, as you know, he's already mentioned, I do have privacy concerns because there are other allegations that, Suggs is gang related, which is supposed to be well, I'm not going to say he's gang related. It's been identified through a lot of, his social media postings. And I'm just really concerned for my safety. And I
understand. You don't have to turn on your camera.
Thank you. And I don't want to say my name either. I've had to disable all of my social media information.
Anybody been contacting you or harassing you?
They did not contact me, but the Denaria Redwine, who's my daughter, they were fishing from information from her to identify me.
All right, what do you want to tell me, please, ma'am?
Well, we did write a statement, but first I'd like for my niece to speak. She's on the line, and then the family advocate can read our statement, if that's okay.
Good morning, Judge. I do have her written statement.
Okay, would you please read it?
January 24th, 2021, a day that will forever scar the hearts, minds, and souls of Marcus's family and friends. Marcus was a decent and funny man who had the respect of many. He may not have been the father of the year, but he wasn't the worst, and it certainly does not give anyone the right to murder. Even in death, Marcus continues to make other families smile by being an organ donor, saving others' lives. At the time of his death, he just welcomed his last child. My youngest nephew was born 2 months before his father was murdered. We are most grateful for justice being served for Marcus. The least that can happen is justice, because as selfish as it may sound, we will never hug him, see him, hear his laugh, or see his smile again, get his advice or anything, and are left to raise his newborn child, who will only know his father through stories, pictures, and videos. His death has severely compromised the mental and emotional health of his mother, siblings, and children. This has left us all heartbroken. In conclusion, Suggs and the Smith family can still see their incarcerated ones, but have deprived Marcus's mother, father, his siblings, 9 children, especially his newborn, and a host of family and friends the opportunity to pray with, see, hear, or touch our loved ones ever again. I hope you consider the extent of his injuries, the murder. This shooting was an overkill, multiple gunshot wounds to the head, face, and body. None of the perpetrators should ever walk free. Anyone capable of such is a threat, and not only to our family, but to society, in my opinion. This was by Kashina Orr.
All right, does the family wish to say anything else?
Yes.
Hi.
Okay, there you go. His daughter, I'm sorry.
Hi, yes, I'm his daughter, and I would like to speak. I would just like to say that I'm glad that the other three did not get denied bond, and did get the not denied bond, and I'm glad that this one is getting denied bond because my dad lost his life for something that he didn't do. Like my dad has so many kids, and I'm one of his oldest daughters. Like he seen me graduate high school, seen me go to college. Like my dad would never do anything like that, and I know these guys because I went to surrounding schools with them, and I know that they have been in trouble before. And I honestly upset that my dad is gone, and I wish that they would just rot in jail. Like I do not want them out of jail at all because this is very hurting of me.
Very sorry for your loss.
Thank you.
Anything else, counsel?
No, Your Honor. I stand on what I've represented to the court.
And yes, Judge, just very briefly, I mean, I'm very sorry for their loss as well, but the fact is Kaiser just did not encourage or assist or counsel or hire these people to do this. And he had nothing to do with the situation besides riding over there.
I'm sure he's got an explanation of why he went over there.
Well, yes, Judge, to pick up
Hey,
the
Judge, I guess at this point, I would.
All right, one at a time.
sexual assault and domestic violence, and they were going to pick her up.
All right, I'm just going to chime in here, Judge. I know
All right,
we're,
one at a time. Go ahead, Mr. Dutcher.
I know we're talking about a bond, but at the bond hearing, the relevant factors are the IALA factors and evidence related to that. Discussing the merits of the case, probable cause isn't even a relevant consideration for the case. So I understand that, we want to make a defense about, oh, well, there was some sort of domestic situation going on over there and that somehow mitigates it, so we should get a bond. That's an improper legal argument. So as much as, we want to flush that out and discuss it, I would object to that as not being proper.
My main concern is you have two witnesses out there. One that is the sister of the co-defendants, and one is another witness, and that witness has given a statement, but the sister of the co-defendants is not.
And Your Honor, if I could say though, too, the IALA factor, speaking of, I'm glad that got brought up, is danger to the community, no criminal record, likelihood to reoffend, no criminal record. So we can't even logically reoffend. He's never offended or been convicted before. And then flight risk, he's been totally compliant on his bond in Clayton, so he's not a flight risk. If anything, that should go in his favor.
My concern is the allegation that he's in a gang. That's my concern.
Yes,
So I'm
Judge.
going to deny bond. Let's move on.
And Judge, does it matter at all though that he has not attempted to tamper or ever tamper even on his other bond? I mean,
My concern is he was out on bond for another alleged violent case, and he's alleged to be in a gang, and then this case comes up. I mean, whether he's being shot at or he's shooting at somebody, he's involved in violence. And so I'm just going to deny bond.
And Judge, I would just say that he's not involved in violence. He's involved in someone lying about him being violent. That's why we're presumed innocent.
Right. Well, the fact that he's alleged to be in a gang is a huge factor for me. So I'm going to deny.
Judge. All right. Thank you, Judge.
All right, let's go to Quintarius Johnson, Ms. Markowitz.
Thank you, Judge. Before you is Quintarius Johnson. He is 30 years old. He has a 10th grade education, was working on his GED.
Please speak up. We can't hear you, Liz.
Really? One moment, Judge.
Okay, that's better.
Judge, if you could just give me one moment to see what's going on. Can you hear me now?
Sure.
Okay. So, Judge, my client is Quintarius Johnson. He is 30 years old. He has a 10th grade education. He lives in the Atlanta area, and the booking at the location in the booking report, because we're on live on YouTube, I try not to put their address unless the court absolutely needs it. He works for Brooks Brothers Construction, has been working for them for the last 2 years. His dad is also on the call. He has a mom that lives in the Atlanta area as well, and 2 children that he supports, a 9-year-old and a 3-month-old. He has no violent criminal history. Judge,
Please speak up. My court reporter's having a hard time hearing you.
he has no violent criminal history. Judge, he's charged with criminal attempt to commit armed robbery, murder, and possession of a firearm by a convicted felon. So my understanding of the facts as alleged in the warrant is that he is supposed to have been the driver of a vehicle where the decedent is gone over to either buy drugs or sell drugs, and then gets into a shootout with another person, Mr. Roberson, who is non-cooperative with the police. My client, the best case scenario, according to the warrant, is that my client never gets out of the car, does not participate in attempted robbery or armed robbery or drug deal at all, and may have not, in fact, there's no evidence that he had actually knowledge of what was going on in terms of anybody having weapons. And so I would argue, Your Honor, even looking at the warrant itself, those facts would say that my client should be entitled to a bond. However, I think there's also evidence that my client may have given the car to the decedent and 2 other people, and then had left his cell phone because family members had tried to reach him. The phone was answered by somebody else. And when his family member made a comment as to asking for to talk to my client, they hung up the phone. And so that will be something that'll have to be fleshed out later. But in terms of the Ayala factors, I'm asking for a bond that we set on the criminal attempt to commit armed robbery, $5,000, on the murder, $50,000, and on possession of a firearm by a convicted felon, $5,000. I don't see where he's not in possession of a weapon, so I don't see where the state's ever getting that at all. And the criminal attempt to commit armed robbery, at this point, they don't have any evidence that my client was involved, other than if you want to believe he was the driver, that he goes over there. The video shows that he stayed and remained in the car. That's in the warrant. That's from the police. My client did cooperate with the police, has gone in and given a statement, and that's where we stand, Your Honor.
Mr. Dutcher?
Yes, Judge. Well, while we're going to talk about the cooperativeness of the other witness who is the victim of an attempted armed robbery, of which this defendant was a party to the crime, as being uncooperative, I would like to address some of the characterizations of this defendant's cooperation during the investigation, since we're going to talk about that. I would characterize his, I guess, participation with the police as not being cooperative. I think the evidence is that there's a witness that identifies him as being in possession of the car. And it wasn't until after the police confronted him with the allegation that he was involved in, what essentially is a felony murder here. The allegation is that he drove to the scene of the crime along with the victim in the case and an unidentified co-conspirator in the crime. Video surveillance, from my understanding, depicts the victim exit the car and brandish a gun, and not just a gun, but what appeared to be an assault rifle. And then the third party in this case, the intended victim of their attempted robbery, the victim in this case and that person exchange gunfire. The victim gets struck, as well as the intended attempted armed robbery victim. He gets struck in the legs. They later locate him in an apartment and recover a gun from him. The defendant, who is alleged to have been driving the car, a second person gets out of that car after the gunfire begins and also begins firing at the intended attempted armed robbery victim. That person then gets back into the car and the car flees the scene. So to say that the defendant allegedly didn't have knowledge, assuming he was the driver of the car, you'd have to believe that he just, willfully didn't know that there was someone in there with an assault rifle, and didn't know that there was another person armed with a gun, and then somehow was blind to the knowledge that a shooting just happened and was there waiting to take the other identified person away from the scene after he had just shot, just a few feet from the car. And also, circumstantially, it's curious that the shooting and the confrontation happened pretty much as soon as they got out of the car. So seemingly to give credence that they were there for a specific purpose for that confrontation. It is the state's position that the defendant gave deceptive and misleading information during the course of the investigation, indicating to me he's not cooperative and could potentially be a flight risk. But looking at the criminal history of the defendant, he does have one. And just going through the convictions, starting in 2009, it looked like there was a criminal trespass conviction in DeKalb County. Of more concern associated with that is it appears that there was a failure to appear on October 13th of 2009. He then entered a guilty plea to possession of tools and theft by receiving in DeKalb County under case number 11 CR 2487. That was on July 14th, 2007. He then violated his probation on February 20th, 2013, and he was revoked for 3 months, and they reinstated him. He then was convicted for family violence, battery, and cruelty to children in the 3rd degree in DeKalb County on January 16th, 2014, under case number 13C 62191. He then violated his probation again, violated his felony probation, it looked like, for theft by receiving. On February 20th of 2014, they revoked him for 6 months and reinstated him. And then he picked up another conviction for giving a false name, obstruction, and the felony offense of identity fraud in DeKalb County under 17 CR 1972. But of more concern, there was also a failure to appear associated with that case on November 29th, 2017. So based on review of his record, while it's not the worst record I've ever seen, we're talking about multiple arrests, multiple convictions, and multiple instances where he was violated for not following the rules and conditions of his probation, giving me no confidence that he would follow the rules and conditions as set forth by this court if he were to be given a bond and abide by certain conditions. Additionally, he's got a recent felony offense, and the nature of the case, a murder case, gun violence in the Atlanta city streets is of, very important public significance. And for those reasons, I would object to this defendant getting a bond. And I believe there's also a family member here for the victim in the case, the victim's sister. So I'm not sure if she wants to address the court, but she may. So I'll ask Ms. Rolak if there's a statement that she wants to give.
Good morning again, Judge.
Good morning.
We do have Courtney Glass, who is the sister of the decedent, and we also have his mom, Valencia Thomas, and I have a statement from her.
All right, please proceed.
This letter is composed of the horrific trauma that I have experienced in losing my child and the call for justice in pursuing justice for his life. I, Valencia Thompson, have suffered a detrimental loss of mental competency due to the death of my son, who was raised in a Christian and very intelligent, educated upbringing in which he has been cheated from enjoying his future. My son was gifted to be a football player since the age of 4. He was a scholar. He was a caretaker who took care of his grandmother, mother, and 2 sisters. My only son, in whom I instilled nothing but love and goodness in his character, shall still be present with us today because so many people loved him and needed him here to fulfill his dreams and talents. My brother was loving, charismatic, and had an infectious smile that everyone he encountered loved. He was a loving son, brother, and uncle. We are no longer able to see his beautiful smile, hug him, hold his hand, hear his soft-spoken I love yous. He can't be here anymore to play with his 7-year-old nephew, who prays his uncle is in heaven now. He will never get to meet his 8-month-old nephew, who his sister carried while having to grieve the loss of his life. We will never be able to see him get married or have children. We only have pictures and memories, while Quintarius' family can still receive calls from him, hold his hand, hug him. Our entire world has been shattered, as he was the backbone and glue to a family of all women. While justice will never bring back our beloved son, brother, and uncle, please give our family a bit of relief and do not allow a bond so we may receive some justice for our beloved Gregory. Thank you.
I'm very sorry for their loss. Do they wish to say anything else? Are they on?
Yes, Judge, this is Courtney Glass. I'm on, but I don't have anything additional.
I'm very sorry for your loss.
Judge, if I may respond,
Ms. Markowitz?
yes, Judge, if I may respond. And can you, I don't know why it's bouncing back again.
All right, how can we stop this, please? What do we need to do? Okay, I need to mute my mic.
Okay. So with all due respect, my understanding of the facts, and I just want to be clear because maybe I misunderstood something since this case is only 2 weeks old. My understanding of the facts is that at worst, my client is a driver of a vehicle where the decedent got out, according to Mr. Dutcher, of the car and had a weapon and assaulted somebody else. I'm confused as to why my client, its family does not, why that the decedent's family doesn't want my client out on bond. I mean, the fact is that he didn't have a gun. My client didn't have a gun. So I'm not sure where this is all coming from. But in either event, 611-131 shouldn't go. Ms. Sanders, what can I do to help? Can you mute yourself?
The only mic is mine.
You're
So I'm
not muted.
I'm gonna mute my mic.
You're not. Is this better? Nope.
She didn't have a mic, so I'm gonna mute mine. Go ahead, Ms. Markowitz.
So, Your Honor, for the 1611-131, while this isn't a probable cause hearing, my client did not have a weapon. So the state can't make that case out. So the bond on that should at least have a bond, and it should be an insignificant amount, meaning $1,000 at the most. On the criminal attempt to commit armed robbery, at this point, I don't see anything that would show that he's a party to the crime. However, even giving that, if that's what the court wants to see, I'll ask for a bond in the amount of $10,000 and $60,000 on the homicide for a total of, what did I say, $70,000 or $71,000. If the court wants to put him on an ankle monitor paid for by the county, which the court can do, then the court would know where he was. He could be in only for, out only for work and medical and court. But he does not have a significant criminal history, and he's not the one out there shooting.
And Judge, just to respond to that, there's very clear case law that the getaway driver is a party to the crime. And if the crime involves possession of a weapon, that of course flows to the party of the crime. So I think that if we're just talking about probable cause, which again has no place in a bond hearing, the court is to consider the IALA factors and the seriousness of the offense and the accused's, I guess, history and character in the community, which from my perspective is not good, which contains multiple violations of probation and failure to follow court rules and felony convictions and commission of crimes. So if the allegation is that he is the driver of the car, the law is very clear that that person is a party to the crime, and a party to the crime is just as guilty as the person who directly commits the crime. And if this crime was committed by someone with a firearm, we know that there were at least 2 firearms that came out of that car, then the defendant could legally be charged with possession of those weapons during the commission of that crime. So that's just my response to that.
With all due respect, the possession of a firearm by a convicted felon would require actual possession. Being a party to the crime on the criminal attempt to commit armed robbery will have to be fleshed out, but it may be a party after the fact, an accessory after the fact, once the shooting happens. But in terms of anything showing that he knows anything's going on before then, the state does not have that at this point. In addition, the state, hold on. And in addition, the state does have in their warrant very clearly that the police officer says that the living witness, Mr. Roberson, was not truthful with them. And so we've got some very interesting arguments.
Can council meet in a breakout room?
Sure.
How can we do that?
Who's facilitating the session?
April? 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 Can you put us in a breakout room, Liz and Pat and me? Okay, do we have to join the breakout room one? Okay, let's go to Rodriguez.
Judge,
Judge, so are we holding on position number 2?
Position number 2, I've decided to grant bond $100,000, 80 on the murder, 10 on the other 2 charges under the 10% program, an ankle monitor, stay away from the incident location, stay away from any of the witnesses, no firearms. He'll be confined to his home except for work, medical, and legal reasons. The
And
county
Judge,
will pay for the monitor.
And Judge, am I doing the bond order or does Ms. Woods? How does it work in your courtroom? In the other courtrooms, you guys do it.
I think we do it.
Okay, just making sure. Okay.
All right, let's go to Rodriguez, please. All right, Mr. Chen and Ms. Stadler, I'm coming to you, okay?
Judge, is there a Spanish interpreter in this case? I think there needs to be a Spanish interpreter for this client.
Rodriguez is in the video. We don't have a Hispanic interpreter. So Ms. Woods, can we continue this case to when? Next week, I guess, in front of the judge?
Hey, Judge, it depends on your availability.
Oh, it's my case?
This will be your case until the case is indicted.
Okay. Let's see if we can get an interpreter maybe tomorrow. Is that okay?
Judge, generally they're available. Do you want me to try to call Mr. Laris and just wait till the end of the calendar?
Thank you, Ms. Markowitz. Well, Judge, you have 2 other cases. Judge, you have a couple of other cases. So if Ms. Liz can get the interpreter before you finish the last case, it'll be fine.
Let's let Liz go and see what you can do, okay?
Thank you.
All right, thank you, Liz. All right.
Honor, sorry, just one quick, I have to report to Judge Glanville. If we're gonna wait on that, do you want me to I have to log off and attend his bond hearing real quick before Judge Glanville.
Are you the only prosecutor?
On that calendar, yes, just one case.
Okay, why don't you go see Judge Glanville? I'll take my civil case real quick, okay?
Yes, sir.
Are you the prosecutor?
Judge, we have some other prosecutors online.
Okay, that's fine. Let him go and come back. What about
Let's finish.
Levi Jackson?
So our next one will be Jackson. And then Travion.
Who is the prosecutor on Jackson?
That's going to be me, Judge Michael Parrish. I don't believe I've appeared in your court before. Nice to meet you.
You too. Don't believe all the bad things they say about me.
Same thing with me.
All right, my calendar's cut off. So tell me the robbery and what else are the charges?
For Mr. Jackson, we have 3 charges here, Judge. We've got a robbery, we've got rape, and we've got aggravated assault strangulation.
Okay, and who is the defense attorney?
Good morning, Your Honor. Jennifer Banks Brown for Mr. Jackson.
Tell me, Mr. Parrish, about the alleged facts, please.
Absolutely, Judge. So the defendant in this case and the victim in this case were acquaintances. They had known each other for a handful of weeks prior to this incident. The day this occurred, the defendant in the case entered the victim's home. He forced himself upon her physically. He did use a condom, so we're still waiting on some sex results on the sex kits. And he took her debit card, later used that debit card, taking out making $100 purchase. And during the altercation, when he was forcing himself on her and strangling and taking her card, he had his hands wrapped around her neck and he was strangling her, Judge. She was able to identify him by a nickname. Officers, through their search and investigation, were able to identify the defendant. He did give a recorded interview, said he knew the victim. His statement obviously matched up in certain ways with what the victim had said, but is missing certain key elements that the state alleges. And that's basically the foundational facts, Judge. They knew each other. He forced himself upon her, took her debit card, and strangled her.
All right, Ms. Banks Brown.
Thank you, Judge. Judge, first I would like to say that my client denies the allegations as outlined by the state this morning, Your Honor. Specifically, he has indicated that he does not have any type of relationship or has known the complaining witness for any amount of significant time, Your Honor. So he does deny all of the allegations. In reference to the bond hearing this morning, Your Honor, Mr. Jackson is before the court. He is 44 years old, Your Honor, and he was born and raised here in Atlanta. He has lived here in Atlanta his entire life, Judge. He does have a stable and valid address. He resides in Union City, Judge, and he resides there with his fiance, and he's been there for over a year and a half at the same address. Judge, my client has significant ties to this community. He's currently working at Yamaha in Noonan, which is a production plant, Your Honor, and he's hoping to get bond so he can return back to that job. His entire family resides here. He has siblings, Judge, that live here. He is a high school graduate, Judge. In addition to working in the community, living in the community, and having family here, Your Honor, he does do volunteer work at Welcome All Park as a volunteer basketball youth coach, Your Honor. So again, in terms of, his ties to the community, I believe that he meets that IALA factor. He is not a flight risk. And Judge, in reference to the additional factors, it is my understanding based on the information that I have that my client does not have any felony convictions, Your Honor. He's 44 years old and has gone this amount of time with any significant criminal history. He does not have a history of committing any violence. There's nothing to suggest that if he is given a bond, that he would get out and commit any felonies or be a risk to the community. Your Honor, we do believe that as time goes on, that there will be additional information that will corroborate my client's claim of innocence.
Does he claim that he does not know this person?
Judge, my understanding is that this person he had seen before. There's a local convenience store in the area where my client lives that he frequents occasionally to play his numbers, and that the complaining witness has been at that convenience store on occasion when he has been there. However, it hasn't been any interactions or any other type of communications between the complaining witness and my client. So he does not know her on a personal level, but has seen her before at the convenience store.
Does Mr. Parrish, what is the evidence that he used her debit card? Is that on video?
Judge, I don't believe it's on video, at least if there is. I have not come in contact with that video yet. Two pieces of evidence that kind of corroborate that. The officers saw the purchase on her iPhone, I believe. And during the interview that he gave, he admitted to using the card. He admitted to using her card to get cash out. And then he admitted to keeping that cash after he dropped her card back off to her at her home. She wasn't there, but he said he left her card at her property, keeping the cash. So those two pieces of evidence, Judge, make it pretty straightforward that he did actually use the card. The question I think will be when we get kind of into the facts, if it was with her permission or without her permission. I think that's really where the argument's going to be made, because he said—
Does he deny the sexual act, Ms. Banks Brown?
Absolutely, Your Honor.
Does he have a felony record, Mr. Parrish?
He does not, Judge. He has misdemeanors, a number of misdemeanors, but no felony convictions at this point.
And Judge, based on my client's lack of any significant criminal history, any felony convictions, we are asking that the court set a bond in this matter. Again, I mean, the allegations are just that. They're allegations. I believe that there's still some information that the state needs to
set bond at $80,000 on the rape, $10,000 on each of the other two counts, total $100,000. He can satisfy that with the 10% program at the jail. He'll have an ankle monitor paid for by the county, and that he will stay away from the incident location, stay away from the alleged victim, and stay away from that convenience store. and he will be at home confined unless he's working or medical or legal. All right, and let's go to Travion Williams. Are you the prosecutor on that, Mr. Parrish?
I am not, Judge. I work in the sex crimes division, so this was my only case on your calendar.
All right, well, the next one is a sex crime.
I think that's actually going to be a different division of our sex crimes, Judge. We have a lot of silos.
Good morning.
Well, how are you, Miss Jones Connor?
I'm good, Judge. How are you?
Now that all I'm doing is divorces, they call it family law, Mr. Shepherd.
Good morning, Your Honor.
Good to see y'all. Are you on this? No, Miss Banks Brown?
It's Kenneth Shepherd and Judy Kim on behalf of Mr. Williams.
Okay.
And then I'll be the prosecutor on that position in the next position, Your Honor.
Tell me about that, please. Williams, tell me the alleged facts, please.
Your Honor, so this, and I don't know if you want that to come from me or Mr. Shepherd. Do you mind? Okay, perfect. So this stems, Your Honor, from an April 7th, 2021 report of a sexual assault of an 8-year-old victim at 930 Newtown Circle in Fulton County. Your Honor, the authorities received a report from the victim's father, Johnny, Johnnny Fleming, Fleming, and he reported to police that his sister, April Williams, called him and told him about a sexual assault of his daughter, initials K as in kite, N as in Nancy, by her son, the defendant, Travion Williams, who was 18 years old at the time. The child, Your Honor, victim in this case, then reported in a forensic interview that she was sexually assaulted multiple times on multiple occasions by the defendant. She was able to identify him. Your Honor, the victim and the defendant are first cousins, so the state does have a concern about the proximity of the defendant to the victim. Also, the fact that the witnesses in this case are all related. So our reporting witness is the father, but the outcry and initial disclosure of what happened is the defendant's mother, but also the victim's aunt. So taking into account, Your Honor, those relations and kind of the complicated nature of the case, the state does have a concern on that end. We would ask that you deny bond. We did speak to the victim's father, and he did adamantly oppose bond as well, and express his concern for his daughter's safety and the fact that she will be living with him this summer, so in close proximity to the family.
Mr. Shepherd, Ms. Kim.
I'm going to speak on behalf of Mr. Williams today, Your Honor. First of all, it's my understanding is that the victim's mother, or the defendant's mother, April Williams, denies ever reporting that there was a sexual assault in her house. She's actually on the phone today, and she's going to be my witness for the Ayala factors. We're not looking for a jury trial today. We're just looking for an Ayala factor. So I'm going to have Ms. Williams testify in a minute about the Ayala factors only. But my understanding is she denies ever telling the father of the victim that her son assaulted the young lady. Also, as far as the state's argument about them being a close family and therefore he shouldn't get a bond, well, that would apply in hundreds of thousands of cases where people get bonds all the time, even though they're part of the same family. In this case, we could easily set it up such that the young lady does not have any contact with my client. They don't live together. There's no reason for them to be together. The young lady can stay at her house and my client can stay at his house, which is not the same house. And there's no reason for the victim to be over at my client's mother's house. So to say that, oh, the victim's going to go live with the defendant's mom and therefore the defendant doesn't get a bond doesn't hold water, because my client's mother does not want the victim in her house if that's going to prevent her son from getting a bond. So I'm going to
tell me how the victim is related to your client's mother.
I believe it's her niece, but there's some. I don't think
so. This defendant is the cousin of this victim.
I don't think it's as simple as that. I think there is a marriage, then a divorce, then another marriage. I don't think they're just part of the same.
Does he have a record, Ms. Jones-Connor?
No, Your Honor, he only has an arrest on a criminal damage to property in the second degree in juvenile court back in
Has
2017.
pretrial been involved in this?
I don't have a pretrial report on this, Your Honor, but if they have some information.
I want a pretrial report on this. And Ms. Woods, let's go 2 weeks out. What is 2 weeks out?
Today is the 8th, so that would probably be
22nd.
22.
Correct.
And I'm out the 23rd, so let's do the 22nd at 11 o'clock.
Who will get in touch with pretrial services to request the report, Your Honor? Would that be
Ms. Jones-Connor to do that?
Okay, Your Honor, I'll handle that.
I want a thorough investigation and interviews. All right.
Yes, Your Honor. My client's mother is on the phone. She was going to testify today, but can we just postpone her testimony?
Yes, sir.
until June
Yes,
22?
sir. Is that it for you, Ms. Kim and Mr. Shepherd?
Yes, Your Honor. June 22 at what time?
11 o'clock.
Thank you, Your Honor. We will see you on June 22 at 11.
Hey, y'all don't even miss me.
Ms. Jones-Connor, can you see if you can get me a copy of that report? If pretrial sends it to you in advance of the hearing, can you forward that over?
They typically just e-file or post it, but yes, if I get that, I'll send it over to you.
All right, good to see all of y'all. Have a good day.
Thank you, Your Honor. We do miss you very much.
You're just saying that, but I'll be back sooner than later. Y'all take care.
Thank you.
Miss
See
y'all
you in
too.
2 weeks.
Shayla Wade, Miss Miller.
And I believe Ms. Wade was.
Judge, that case has been resolved and it actually has been MPGJ'd.
Okay. Then Mr.
Ms. Markowitz, do we have an update?
I think I got an interpreter, so let me just scan her back the information. I just told her we need one quickly for the court. I called Jared Early, who's with court admin.
All right, well, let's wait on Pat to come back.
Let
I'm
me just
gonna
go scan this. I'll be right back.
All right, you can come back. Let's take Bumpus versus Johnson, Mr. Chen and Ms. Stadler.
Yes, Your Honor. Christine Stadler here on behalf of the respondent. And
I appreciate y'all's patience. I am presiding this week, which means it's chaos. All right, Mr. Chen, are you there?
Yes, I should have said here, I'm here. Thank you, Judge.
All right. So basically, we're talking about an allegation that the father has withheld visitation from the mother. And we've got some allegations that he's not allowed the mother to be an emergency contact with the school. And we've got a child support modification and a contempt for non-payment of child support. Is that what we have here today?
yes, Your Honor, we have a 16-year-old child. I have filed a motion for the court to interview the child. The child has already filed an election and has actually talked to, I believe, the caseworkers at the court with regards to his election and his desire to continue to live with the father and visit with the mother as him and the mother shall agree. And we do want the court to be able to interview him since he is 16.
Is there any doubt, Mr. Chen, about the election, about the appropriateness of the election?
No, Your Honor.
All right. Well, so the child's going to live with the father, and the mother's going to have to pay child support, I imagine. And is the visitation going to be kind of loose, just as they can work it out? I mean, is it a situation where we can co-parent this child?
Your Honor, my client, since the child is 16, my client is fine for the mother and the child to work out the visitation as they desire. Mother lives in Texas, and we're asking that, the problem is the parties were meeting in Tennessee. My client would go, she would not show up. She would go, supposedly my client wasn't there. So there was an issue. So we're asking that any visitation that she fly the child out to him. He's old enough to fly by himself. Airfares are about $250 to get out to where she is.
Does the child want to see his mother?
Your Honor, I did speak with the child yesterday in preparation, and he does want to see the mother, but on his terms. He wants to be able to say, because he is a straight A student and he is in other.
Well, I don't have a problem with a 16-year-old organizing their life. And he does want to see his mother. Mr. Chen, is your client here?
Yes, Your Honor. My client is Valerie Bumpus. I think she need, Valerie, could you rename your label to, and from iPhone to Valerie Bumpus, and then my associate Kara Down is also on. But yeah, if you want to talk to her, she's on.
All right, Ms. Bumpus?
Yes, I am here.
Where's that you? iPhone here, that's you? Okay.
Yes.
So your child does want to see you, and you're just gonna have to work it out with your child about how you're gonna visit him.
I'm kind of against that because he has asked his father several times. This order been going on since 2015, and Mr. Johnson has deliberately just not shown up. I've only missed one visitation since the whole order, and he just won't bring them. So
All right,
even
well,
fly him.
you live in Texas, the child can fly out there to see you.
Correct.
Okay. And Mr. Johnson?
Yes, sir.
I don't want any hindrance of the child seeing his mother as he wishes.
Can I speak? Yes, sir.
Yes, sir.
What she's talking about in 2015 has already been handled multiple times, which is inaccurate information. Next is I have multiple family wizard messages and pictures where I showed up and she did not come, even text messages where she said, I'm not using the family wizard or whatever. So, and we have to speak on this every time we come to court, that she constantly bringing up matters that were already handled. So as far as her not seeing him this time is not my doing and never was my doing.
All right. Let's talk about the future. We can't look at life through the rearview mirror. Let's look at life through the windshield. I want this child to have a good, positive relationship with both parents.
Yeah, me too. Me too.
So
I don't have a problem.
So this child is probably what, a junior in high school next year or senior?
Yeah, he'll be in 11th grade next year. Yes, sir.
Where is he in school?
At Maynard Jackson.
All right. So how are we going to handle visitation for the summer?
He's actually supposed to be with me now. Like I said, he's basically exhausted 100 and something odd days, even from the last order.
Can I speak?
Yes, sir. Hang on a minute. Let me put the child on. Where's the child, Ms. Stadler?
Mr. Johnson, can you make the child available?
Yeah, let me walk in the house. Hold on.
Your Honor, while he's walking in the house, while I was speaking to the child, I asked him about this summer. He said he was fine with going for a couple weeks of summer, and we just want the child and the mother to figure out how that would work. And we're asking for only 30 days notice of any visitation she wants with confirmation of travel plans.
Turn it off.
Hello. All right, Mr. Johnson, is the young man on?
Yes, sir.
All right, what is your name, young man?
Joe Johnson II.
Your mom's on here. And my understanding is you're 16 years old. You got a lot going on. You want to see your mother, but y'all want to work it out where it's convenient for both of you. Is that right?
Yes, sir. Yes, sir.
And you have things going on in your life. You're going to go see your mother this summer?
Yes, sir.
Okay. And when do you want to go?
Sometime in July.
When are you involved? What are you involved with this summer? I know you're going to be a junior in high school at Maynard Jackson High School. What's going on in your life this summer?
I play basketball.
So do they have basketball camps?
Yes, sir.
For school?
Yes, sir.
When is that?
It's going on like next week in June.
Can you go see your mother for the whole month of July?
Yeah, I can.
Okay, when does school start? When does school start? Probably about August 2nd?
August, yeah, like August.
Maybe the 2nd or the 9th?
Yeah, through that time.
All right, why don't we say, how are we gonna pay for the ticket?
He should be able to pay for him to get there, and I should be able to pay for him to come back. I just think that's fair.
All right, let's do this. Let's split the round trip ticket.
Can I speak?
Yes, sir.
I don't agree with me paying, and the reason being is because she is still behind in child support, and that is something that we go through every year. She does not help me with him at
Ms.
all.
Stadler, how much is the child support?
Right now, she's only paying $150, and according to my child support calculations, her child support should be $550.
Well, it's already paid. Everything is a zero balance. So if
And
you
we
call,
when did you pay it last night?
Hold on, Your Honor, I do have a online report that she currently owes $1,334 in child support as of yesterday from the child support receiver's office, and I do have that.
Where do you work, ma'am?
I do have a confirmation receipt. It is paid in full, and the only reason why it wasn't
When did
being
you pay that?
I paid it last week on the 4th.
Like $1,300?
$1,852 to be exact.
$1,852?
Yes.
All right, well, let's show proof of that to Ms. Stadler. The child support is what, $150 a month right now? What do you do for a living, ma'am?
I work at a pharmacy, but I only bring home about $2,000 a month, and I have 2 other small children as well.
All right,
Tell them about your her business that you got
Daughter, she
online.
also has another business online that she has.
That is not my company. You cannot prove it, and I do not file that on my taxes. So that is not valid.
It's her company. It's named after her daughter, and she is all on there by herself.
All right. All right. Ms. Stadler, can you verify the $1,800 payment?
It's not showing up in the child support receiver's office, Your Honor. We just had took a screenshot yesterday as of the 8th, as of the 7th, and it was still showing $1,334 owed.
Well, it tells me 5 to 7 business days before it's actually posted, because
All right, well, let's contact them, Ms. Stadler. I'm gonna take a break and go back to this criminal. Let's contact them and we'll come back, okay?
Okay, yes, Your Honor.
All right, everybody hold on the line. Ms. Stadler, please do that.
Thank you.
Miss
Judge, we need to wait for Miss Sanders. She's on her way back.
Okay, all right, Miss Markowitz, we have our interpreter. And
I
Miss
think we need Dutcher.
Pat,
He may be still being Glanville. You want to email Glanville quick and see if he.
all right, let me see what I can do.
Thank you, Claudia. I appreciate you. Sorry.
My pleasure. No problem. Elizabeth.
Yes.
What is the first name of the LEP that I'm interpreting for? I can't understand it on the.
Lucio.
Lucio, okay.
Lucio.
Okay.
For the client?
Yes.
Yes, I think it's Lucio Rodriguez Hernandez.
Okay. Thank you.
Oh, looks like Pat's on.
Yeah, I'm back. Are we ready for,
Yeah, we have an interpreter as soon as the judge gets back.
okay,
Hey, Pat, you're back?
I'm back.
Okay.
All right. Thank you, Madam Interpreter.
You're welcome, Your Honor.
So, this is Mr. Rodriguez. Tell me, Pat, the alleged facts, please.
Judge, this incident occurred on May 8th of 2021, and it is the shooting death of what the police characterized in the warrant as John Doe.
Su señoría, este es un caso que se alega sucedió el 8 de mayo del 2021, en el cual se alega que hubo un tiroteo y es de acuerdo a lo que cita el caso John Doe.
Right, Madam Interpreter, please raise your right hand. Do you swear that you will truthfully interpret?
I do.
Okay.
And Judge, can we just make sure that Mr. Rodriguez Hernandez can hear her? By him.
Can you hear her?
Señor Rodríguez Hernández, ¿puede oír al intérprete? ¿Ah?
Sí.
Yes.
Pat?
Yes, Your Honor. Our office subsequently learned the identity of the victim in the case is Adrian Zavala.
Posteriormente se identificó a la víctima como Adrián Zavala.
That's Z-A-V-A-L-A.
Z-A-V-A-L-A.
We reached out to his spouse, Maria Chavez, but we're unable to get her on the Zoom here today.
Y nosotros nos comunicamos con la cónyuge, la esposa María Chávez, pero no pudimos hacer que ella pudiera entrar hoy a esta comunicación por Zoom.
The allegation in the case is straightforward. This was an argument that took place in a trailer park in the jurisdiction of the Atlanta Police Department.
Este es un caso en que los alegatos son bastante directos, en que hubo una discusión en un lugar de donde se estacionan casas móviles bajo la jurisdicción de la policía de Fulton.
The victim, the defendant, and others were congregating and socializing when the victim allegedly said something disrespectful to the defendant.
Estaban juntos ahí cuando la víctima vino y le dijo algo irrespetuoso al acusado.
The defendant went to his trailer and retrieved a .22 caliber revolver.
El acusado fue a su casa móvil, a su tráiler, y sacó un revólver de calibre 22.
And came back and shot the victim in the head.
Y vino de regreso y le disparó a la víctima en la cabeza.
The police arrived, executed a warrant on the defendant's trailer, and located the gun with 2 spent casings in the chamber.
Y la policía vino, fue a investigar esto dentro del tráiler del acusado, donde encontraron el revólver en que se habían utilizado 2 de los casquillos del arma.
So that's just the general allegation, Your Honor. We ran his criminal history.
Eso es básicamente lo que es el caso. Nosotros revisamos sus antecedentes penales.
And nothing came back on file for him.
Y nada apareció con respecto a él.
So I contacted the detective, I believe it was Detective Sluss. Let me just confirm this.
Y entonces yo me comunico con el detective, me parece que fue el detective, déjeme confirmar el nombre.
And to inquire about the defendant's immigration status.
Para hablar con él sobre la situación migratoria del acusado.
Detective Sluss contacted Agent Jeff Stevens with ICE, Immigration Customs and Enforcement.
El detective les habló entonces con un agente de inmigración y aduanas. I'm sorry, what is
Immigration Customs Enforcement, ICE.
Yeah, I know, but what is the detective's name in ICE?
Jeff Stevens.
Josh Stevens es el agente de inmigración y aduanas con el cual se contactó el detective Les.
And Agent Stevens determined that the defendant came here and was granted a 2-month agricultural work visa in 2018.
Y se determinó, de acuerdo a lo que dijo el agente Stevens de inmigración, es que él vino aquí con una visa de agricultura de 2 meses en el 2018.
And that was to work in the state of Louisiana.
Y eso fue para trabajar en el estado de Luisiana.
So he stayed past the 2-month term, left Louisiana and moved, I guess, illegally to Atlanta.
Entonces él se pasó de los 2 meses que tenía de permiso, se fue de Luisiana, me imagino ilegalmente aquí, indocumentado a Atlanta.
When he was arrested, he had a resident alien card or green card.
Cuando se le arrestó, tenía él una credencial de residencia permanente que en inglés se llama green card.
And according to Detective Sluss, he ran that information by Agent Stevens, who advised him that the green card or resident alien card was a fake or forgery.
Y entonces el agente Les se enteró por el agente Stevens que esta tarjeta de residencia permanente era falsa.
And my understanding now is that he has an ICE hold on him, or may have an ICE hold. But either way, we're opposed to bond because I think there's clear evidence he's a flight risk. If we give him a bond, we probably will not see him again.
Y bueno, existe una orden de detención de inmigración y aduanas. De cualquier manera, estamos opuestos a que se le otorgue a salir bajo fianza debido a que se corre el peligro de que él se dé a la fuga.
I think he's clearly a flight risk. I mean, there's no question.
Es claro que sin ninguna pregunta que él esté a riesgo de darse a la fuga.
Is there anything you want to say, Ms. Markowitz?
Judge, yes. Mr. Rodriguez Hernandez is 27 years old. I believe his girlfriend is on the call right now. He does not have any criminal history. He works construction.
And then please speak up, Liz. We can't hear you.
He is 27 years old. He has a middle school education. He works construction. I believe his girlfriend is on the call as well. He does not have any criminal history. He does have an ICE hold, and so if he was to make the bond, he'd go into ICE custody. He wouldn't be getting anywhere.
Bueno,
Liz,
señorita Markowitz, licenciada Markowitz, ¿nos puede decir al respecto? Sí, el acusado tiene 27 años de edad. Él terminó la escuela secundaria, no tiene antecedentes penales, él trabaja en la construcción y me parece que su novia está en la llamada telefónica. Si a él se le otorgara la fianza aquí, pasaría bajo custodia de inmigración y aduanas. Así que no iría a ningún lado.
All right, I think he's a flight risk. I'm going to make that finding and deny bond. Good to see everybody. I think that concludes the criminal calendar. Y'all take care.
Mi fallo es que se le niega la fianza porque estaría a riesgo de darse a la fuga. Ese es mi fallo. Gracias, que tengan buen día todos. May the interpreter be excused, Your Honor.
Yes, ma'am. Thank you. Good to see everybody. Let's go back to Ms. Stadler.
Thank you.
Thank you, Judge.
All right. What did we find out, Ms. Stadler?
Your Honor, hold on one second. Let me just get my screen up. My client has called the Georgia Department of Family Child Support, and the last payment received was in December of 150. Mr. Chin has sent me confirmation of a payment. However, the confirmation it states that it's a June 4th payment, and we believe that is the payment she made last June 4th to catch the child support arrearage up. We don't
It was
believe
just
it's
paid on Friday, and it takes 5 days to post.
All right, so you're saying we're all in agreement, the arrearage is paid up.
We don't know, Your Honor. We have not gotten, it has not been received by Georgia.
I'm
telling you.
Let me explain.
It's not going to be received by Georgia because I have to pay Texas first. So in order for payments to be made, Texas have to be notified first.
So now this 1,300 is as of today that we just called.
All right.
Sir.
You know it would be inappropriate whatsoever to make a misstatement to the court. You understand that?
Right. So I would not lie. I mean, it's in my bank account. I just
all right. So does that bring it current through June 1st?
Yes, it was $1,852.
All right.
And I have to pay Texas, not Georgia.
But they're saying that your income should be $500 a month. I'm going to raise the child support to $300 a month. I'm going to ask that you buy the plane ticket for the child to come out July 1, return July 31. And you and the young man can work out visitation since he is 16 years old.
Can I say something? This is supposed to be a trial. So therefore, the pleadings that I have are not being heard. That I don't think that I should be able to pay because we have joint legal, because Mr. Johnson has missed over 300 and something visitations willingly in contempt. I don't know where they live. I don't know
because your child has been saying he doesn't want to come and see you.
All right.
Y'all
don't talk over each other.
I'm trying to talk I mean, it seems like
I'm gonna let you talk. Go ahead.
Okay. So we have joint legal custody. I don't know where he lives. I'm just now finding out what school he goes to. He has violated every order that we have, knowing and willingly. So I think it was more than fair if he paid for him to get there one way and I pay for him to get there back. If child support has to go up, it needs to be a trust for my son when he turns 18. Because I have cash app records of me my son money every single month. So I just think that is so.
George.
Yes.
Be
Judge,
quiet.
can I speak?
Not your turn to
wait a minute. Let the father speak.
I don't have much to say, but what I will say is this. Every court case that we has had, I have shown proof. She knows when his birthday is before I do because she had him. Okay. Since I've had him for like 7 to 8 years. She may have done something for his birthday twice. And one time it was buying a cake. She has not, she is on his court papers because that's another court case that we already handled that she's bringing back up. Is already closed. Which is, hold on, let me speak. Which is when he was in
one at a time. Listen.
When he was in elementary, she wasn't on his paperwork because she came and checked him out before without my knowing. So when I went to court about it, they told me to add her on his paperwork, but they had to call me in order for her to check him out because that is considered private. So she is on his paperwork and she keep bringing up things that has already been handled in court before. My lawyer knows that as well as her lawyer. We're talking about today.
He's changed.
Right, look.
Out my notification.
Assuming the child support is paid current through June of this year, you both have competent legal counsel.
It's not.
And we're going to find out.
Can you let him talk?
We're going to find out. So, assuming the child support's paid current, we're going to pay $300 a month beginning July 1. We're going to split for now the plane ticket. So whatever the plane ticket is, whenever the child goes out there, it'll be split. Okay. And it would be prudent for the child to go out there when the child has longer periods of time, maybe at Thanksgiving, maybe at Christmas, the month of July. Okay. So Ms. Stadler, I want you to prepare me an order saying the child support will be $300 a month, July 1. put in the order that the mother has claimed in open court that she's paid current with this $1,800 and something payment, that they will split the airfare for the child to go out there, that the mother and the child will work together to figure out when is appropriate for the child to come out there. The father will not inhibit the mother's visitation. Do you have your son's cell phone number, ma'am?
I do. But can I say?
Yes.
Mr. Johnson has not complied with anything that you guys have said since this has all started.
Well, what we're going to do is the
Can I
child.
ask, if I
Can you
haven't,
let me
and I,
speak?
Hang on, please stop.
Please be quiet.
if I
All right,
haven't,
the mother will be listed as getting all the information from school. The mother will get medical records of when the child goes to the doctor. How is the child getting health insurance?
I pay the health insurance. I have done everything for him. And everything that she's talking about is old.
Listen,
and that's what I'm saying. You can go pull up any court record.
Listen to me.
If I haven't complied, I have a question.
What
I let her speak.
for
If
me?
I have not complied,
what would you like for me to do?
Never.
If you don't let me see him, what would you like from
All
me?
right. The child has agreed that he's going out there the month of July. Book the airline ticket. Ma'am, you booked the airline ticket. Y'all communicate on Family Wizard. Are you doing that now?
We can't communicate. That is the problem. That is what you don't understand. We do not talk. We do not speak.
Okay, all right. Here's how we're going to do it. Y'all are paying these fine attorneys with fine reputations. You contact your attorney, ma'am, Mr. Chin.
He needs to be emancipated. If that's the case, because I can't talk to Mr. Johnson, Judge, I can't speak to him. He does not talk.
Okay,
he does not communicate.
You know what? It's going to cost you money, but y'all communicate through your attorneys. All right. So you communicate with Mr. Chin, who communicate with Ms. Stadler. That's the way we're going to do this. We don't have much longer because the child's 16 and all this is going to go away when he's 18 or graduates from high school, whichever occurs first. So
on a court case this is, because I know if I'm the petitioner and I am the one who filed this paperwork to get something done because nothing has been done, I don't think it's fair that nothing.
That's because you haven't done nothing in 8 years.
Be quiet.
All right. What is it you want? I think I'm giving you what you want, ma'am. I'm making him pay half the airfare. They want you to pay $500 a month instead of $150. I'm going up to $300, not $500.
But
this is not healthy.
I have missed so many visitations. I have missed.
That's your fault. That's your fault.
You
cuss your own son out.
Stop.
You cuss your own son out.
All right.
Can you quit you so I can talk? Because
I'm fine. We're trying to move forward, and you keep talking about old stuff. We're trying to move forward. He's trying to give you what you want.
All right.
You're not listening to the judge.
You won't shut up.
All right. Now look,
Jesus.
Mr. Chin, are you willing to communicate with Ms. Stadler? We don't have much longer.
Yes, Your Honor, I am.
All right. So
I will put that in the order, Your Honor.
You communicate with the lawyers. We're going to book an airline ticket, ma'am. You're going to book it. And you tell Mr. Chin, who's going to tell Ms. Stadler how much money that the father's going to owe, so we can offset that from the child support.
He can just pay it on his end. Pay the return ticket.
Have to book a round trip ticket.
Judge, I'm so sorry. It's her. She's constantly saying something that it's making me respond.
Now look,
I agree with you,
ma'am. Book the
ticket. I
agree
with you.
Okay, I will. Thank you.
Wait a minute. Book the ticket on July 1, return in July 31st. Book the ticket. Okay. Tell Mr. Chin how much it is. So if it's $300, then you get $150 offset on your next child support payment. So whatever it is, you can offset it from your child support.
That's perfect.
Miss Stadler and Mr. Chin, does that cover everything we need to discuss?
Yes, Your Honor.
Mr. Chin?
Would I like a finding of contempt on the 217 days that my client missed in attorney's fees?
Your Honor, we have the child that's willing to say that he's the one that did not want to go.
Because she
There was
cussed
an
him
all, there
out.
was a physical.
All right, I'm not gonna find anybody in contempt. I'm not awarding any attorney's fees. Submit me that order, and that's what we're gonna do. Y'all have a good day.
Thank you, Your Honor.
Sorry.